But they're not in that group of.
I don't know. The county attorney, I have no idea what it is, but I got them from the county attorney. So it's me to come back and testify.
Well, I can't agree that the documents that are not in the certified bundle are properly admitted as part of the exhibit.
Okay, Ms. Merchant, would you like to repackage and present to Ms. Cross Defense Exhibit 14?
They're exactly what I got from the county attorney. Apparently, they didn't want to testify, so they gave us a certification but didn't put these in, so they're going to have to testify. I got them from them.
The documents that, the difference between the two document productions, what is the difference?
They didn't even
Credits,
get these.
bank records, credit card statements, things like that wouldn't ordinarily be part and course of the Fulton County records.
But I got them from the Open Records portal, so that's where I printed them.
No, I understand. But the difference in production, Ms. Merchant, you've taken a look at them and they're actually material to your case?
Yes.
In what way?
They're all of his invoices, Judge, and then he has it's just, this is what I got from them. It's all of his invoices, and one of the invoices is a reimbursement that he printed some things, but it's like for the reimbursement. I mean, I don't really care if they take the reimbursement out because they actually are already admitted in the other exhibit I did.
I don't have any problem with the invoices. The invoices are clearly for the records and contained in the certification. So if we remove the items that are in dispute, then I don't have an objection to that.
They're already in exhibit.
So you're removing them?
Yeah, that's fine. You want to take them out?
All right, so again, let's have opposing counsel look at a revised Exhibit 14 and then I'll hear whether there's any objection.
The revised exhibit number 14 contains only the invoices that were submitted, and the state has no objection.
All right, then, not seeing any other issues from other counsel, we'll note Exhibits 14 through 18 have been admitted for the record without objection. I think at this point, it'd be good to make sure we've got, I think, 1 through 18 with the court reporter.
Others? Do you want me to get them to the witness?
Let's, if he's done looking at them, let's just get them all compiled and organized and with the court reporter in case other defense counsel are going to reference them. No, it wasn't for him to have them all. We just need to have 1 through 18 organized with the court reporter. Yeah.
So you want me to take all these back?
I think we ought to do that.
Thank you.
Yeah.
Okay.
All right, as Ms. Merchant is doing that, let me go down the list. Mr. Sadow.
Your Honor, if the court will permit, Mr. Gillen is going to ask some questions that I was going to ask. I'd like to be able to just follow up if there's anything you can touch on. That'll work.
Let me just to keep it consistent, I'll go in order. So Mr. Sadow is deferring, then I'll go to Mr. Stocks.
I'll defer to them.
Mr. Durham on Zoom.
No, Your Honor.
All right, Mr. McDougald.
I will defer to Mr. Gillen.
All right, Mr. Rice. All right, thank you, Mr. Gillen.
Thank you, Your Honor. Good afternoon, Mr. Wade.
Good afternoon, sir.
A few follow-up questions. I'd like to start off with the exhibit number 4 that you should have up there. Those are the interrogatories.
No, sir.
They're not up there?
Remember, I asked her to compile them all, so
I'm
now you can
sorry.
grab
Right
them.
here, I'm going to give it to you. If you want me to come over.
Yes, sir.
Okay. Now, these are the interrogatories that you had filed on May the 30th, 2023 in your divorce case, correct?
Yes, sir.
Now, you went over in part some of those interrogatories, but what I want you to do, because I want to get down to the specific language to clear up exactly what the interrogatories asked for and exactly what you answered, okay?
Yes, sir.
Now, if we look on the interrogatory that I believe, as we indicated, they're really, I think, on page 2, the one that starts off, describe each instance in which you've had sexual relations. You see that one?
Yes, sir.
All right. Now, that interrogatory begins, describe each instance in which you have had sexual relations with a person other than your spouse during the course of the marriage, including the period of separation. You see that?
Yes, sir.
Now, these were filed on May the 30th, 2023, correct?
Yes, sir.
Now, at that time, you had had sexual relations with Miss Willis, correct?
Well,
Your Honor, I'm going to object to the question as phrased. I think the question is properly, at that time, certainly asked about his answer, but I object to.
All right, Mr. Gillen, I'll just ask you to rephrase, but I think you can make the same point.
Well, Your Honor, it's a specific interrogatory, and I would, so the words do matter, and I would like him to answer whether or not he'd had sexual relations with Miss Willis, because if he answered yes, then this interrogatory is a false interrogatory. So I would ask the court's indulgence. I'm not here to jump into some salacious bedroom situation, but this is an interrogatory that matters. So I would ask the court's indulgence.
Ms. Cross?
These questions have been asked and answered several times. I understand Mr. Gillen is coming at it from a different way, but this question is not substantively different than those that have already been asked and answered in the information that he is seeking.
All right, Mr. Gillen, I'll allow maybe this question one more, but I think you are asking it in a different way, and I'll ask you to stick to the point.
Right. Now, as of May the 30th, and may I answer the question that okay, thank you, Your Honor. As of May the 30th, 2023, you had had sexual relations with Miss Willis, isn't that correct?
The interrogatory, sir, asks during the course of the marriage and the period of separation.
Excuse me.
My response,
Your Honor, I would ask that the court direct the witness to answer my question, yes or no. As of May the 30th, 2023, had you had sexual relations with Miss Willis? Yes or no?
Mr. Gillen, let's start with at the higher level whether he believes he answered it truthfully, and then we can drill down into why or why not he doesn't, and maybe we'll end up exactly where you left us.
Well, but again, Your Honor, the point of it is that the words matter, and that we have to establish what did and did not happen, and then he can give whatever explanation he chooses to what apparently is a false answer. But I would like an answer to my question.
And you may get one. I would like us to start at the high level before we drill down into specifics to see whether he actually contradicted that interrogatory, if I'm making sense.
Well, the interrogatory is relatively direct and explicit. Sexual relationships with a person other than your spouse during the course of the marriage, including the period of separation. That's pretty simple.
Sure. Let's see if that's something you can get him to admit.
You did have sexual relationships with someone other than your spouse during the course of the marriage and during the period of separation, which included up to May the 30th of 2023. Isn't that correct, sir?
my answer to this interrogatory is none, is no.
So you're saying that you did not have sexual relationships with anyone outside of your marriage, and the period of separation is during the period, then you're answering the question to this interrogatory, correct, sir?
I'm saying during the course of
Yes or no? Let's just get down to it. Did you or did you not, by May the 30th, 2023, have had sexual relations with Miss Willis, yes or no? Yes or no?
Yes.
Okay. Now, what you did is you answered no to that question, didn't you, or none, correct?
I didn't answer no to the question you just asked. I answered no to the interrogatory question.
And the interrogatory stands that you answered as a pleading in a civil proceeding, your divorce case, right?
Yes.
Now, excuse me. The next interrogatory, let's move there. That interrogatory states as follows: identify any and all occasions in which you entertain a member of the opposite sex other than your spouse who is not related to you by blood or marriage. You see that?
I do.
Now, there are two parts to this. The second part is, I read on, or in which a member of the opposite sex other than your spouse, not related to you by blood or marriage, entertained you. And then it goes on to say, including but not limited to dining, drinking, in restaurants, bars, pubs, hotels. You see that, correct?
I do.
Now, as of May the 30th, 2023, when you filed this interrogatory, you had in fact entertained Miss Willis on many occasions, had you not?
Again, during the course of the marriage. The marriage was irretrievably broken in 2015.
Well,
the answer's still no.
Let's read what the interrogatory says about the time period required to answer the interrogatory. Because what it says is, it goes on to say, including but not limited to dining and or drinking at any restaurants, bars, pubs, hotels, or persons' homes from the date of marriage to the present. You understand what the word present means?
I do.
And present means the filing on May the 30th, 2023. Isn't that right?
It is.
So as of May the 30th, 2023, you had done a lot of entertaining of Miss Willis, had you not?
I had done some, yes.
And in fact, under your testimony, you would have said that she had also entertained you. Isn't that correct?
Yes.
And so your answer to this interrogatory is false, is it not, sir?
No, it's not false.
Well, hate to dance around the answer is yes, you did entertain Miss Willis, correct? Right?
Yes.
She's not your spouse at that time or any time, correct?
That's correct.
She's not related to you by blood or marriage, correct?
That's correct.
But you entertained her, right?
Yes.
And during the course from your marriage, the period of time up to the present, so the answer would have been, yes, I did entertain somebody, correct?
During the course of the marriage, no.
Mr. Wade.
Mr. Gillen, I think we've made a point. I think it speaks for itself, and we can save that for argument.
I'll just follow up with one quick question. You understand what the word present means?
Your Honor, that's been asked of us.
I think we did cover that already as well.
Okay. Now, what has happened from the time that you filed this court document in May of 2023, let's go over some of the things that you have been involved in terms of being entertained or entertaining. Prior to your filing on the answer on the interrogatories on May the 30th, 2023, we've already established, have we not, that you had paid for a Royal Caribbean cruise to the Bahamas with Miss Willis, correct?
Yes, sir, with Miss Willis and my mother.
Well, your mother's not part of this interrogatory. I'm talking about Miss Willis, okay? So you paid and caused to be paid approximately $3,335 on that trip, Bahamas trip, from October the 28th through October the 31st, correct?
Your Honor, objection. I think we've touched this ground several times already.
Mr. Gillen, let's cover new ground.
Well, I'm just trying to establish with specificity the things that he had done to entertain or be entertained prior to May the 30th, 2023. I'll try to move through it
Sure.
quickly.
Well, that's already part of the record in terms of his prior testimony, and so if you want to link those two things together, you can do that during argument.
Well, so let me discuss this. You indicated that during the course of your explanation concerning the Belize trip, that Miss Willis paid you all that money back in cash. Remember?
Yes, sir.
Now, the Belize trip had just happened, hadn't it? That occurred in March of 18th, 2023, right?
Yes, sir.
So you're filing this maybe 2 months after you have gone to Belize with Miss Willis, correct?
Your Honor, again, I believe all of this is our.
I think you might be getting somewhere new. We'll see.
All right.
Yes, sir.
So we've got the trip in to Belize on March the 18th, 2023. You and Miss Willis, correct?
Yes, sir.
Now, 2 months later, you file the interrogatories that speak for themselves that we've gone over a few minutes ago, correct?
Yes, sir.
Now, the March the 18th, 2023, to state the obvious, is before May the 30th, 2023. Will you agree with me on that?
I do.
Okay. So then you tell us that Miss Willis paid you in cash all the money for the entire trip. It was a gift for you for your birthday, correct?
Yes, sir.
And I'm sure you probably have the deposit slips where you took the cash and deposited the cash into your account, don't you?
I did not deposit the cash in my account.
You don't have a single solitary deposit slip to corroborate or support any of your allegations that you were paid by Mrs. Willis in cash, do you?
No, sir.
Not a single solitary one.
Not a one.
Now, when Miss Willis would pay you in cash, would you scamper down to the ATM with her and as she drew money out of her account
Your
to
Honor.
pay you these thousands of dollars?
Mr. Gillen might scamper, but there's been no evidence that Mr. Wade does. I object to the phrasing, the argumentative nature of the question.
All right. On that issue, overruled.
Did you and Miss Wade scamper down to the ATM machine and have her draw out? For example, on the Belize trip, just on your payment would have been $2,794.
Miss Wade,
For clarity, yeah, thank you.
Pardon me?
Miss Wade and I didn't go to Belize.
No, excuse me, Miss Willis. I'm sorry. Did you go down to the ATM with Miss Willis while she drew out $2,794 to pay you in cash? Did you go to the ATM with her?
No, sir. She didn't go to the ATM. She carried the cash.
Oh, and so she would give you the cash. Did you have a little place in your house where you just stack up all this cash that you apparently got to repay you for these benefits that you bestowed on her?
And Mr. Gillen, if I answered that, I'm putting myself in jeopardy. If I tell the world that I have cash someplace in my home, don't you think that could be problematic?
No, I don't. I want an answer as to whether or not you have a little cash hoard in your house where you have allegedly taken the money that you got from Mrs. Willis and went and put it somewhere. Where'd you put it?
No, sir.
Now, just put it on the hip and kind of walk around money?
Did I put it on my hip
Yeah, just walking around money where you would spend cash yourself?
Let me finish. Did I put it on my hip in Belize and walk around with it?
When you got paid back, would you take the money, the cash that she gave you, and would you just carry it around with you for spending money around town?
So we have to break down each trip because, for example, for the cruise, she paid me the money before we took the cruise. So I was here, and I could put the money in my pocket or put it away wherever I wanted to do with it. Other trips, she would give me the money there. So at that point, I could either spend it or put it in my pocket or put it in the hotel safe.
There's no special place that you would have all this cash that you would be getting from her that you've told us about to payback for the benefits that you have bestowed on her?
The only special place that that cash would have gone would have been to one of my children.
Okay. Now, are you aware, have you discussed these pleadings with Ms. Willis?
No, sir.
So there's been no discussion between you and Ms. Willis about the allegation concerning the benefits that you have bestowed on her. Is that correct?
The phrasing, the benefits bestowed upon, I don't believe that's an accurate reflection of the testimony, and I don't think that's an appropriate question.
I think overruled. You can answer the question.
Okay. When you say proceedings, are you talking about the divorce proceedings? Because we were talking about the interrogatories. To that question, the answer is no. If you're go ahead.
I'm sorry. Go ahead with your answer. I'll hear the complete answer, then I'll follow up.
Okay. If you're asking me about this hearing, the proceedings of this hearing, have we discussed the financial piece based upon Mr. Roman's motion? Yes.
So you have discussed the financial piece. Where did that discussion take place?
Conference room.
Were you other people there, or were you and Ms. Willis discussing this about what your position was going to be?
The relevance of this.
No?
Mr. Gillen?
And the relevance has to do with suddenly we have a declaration from Mr. Wade in this case, where he says roughly equal, and then shows one alleged payment by Ms. Willis. No mention of cash, none. So I need to find out a little bit more about how suddenly we have this revelation about cash from the witness stand today.
All right. Overruled.
So we part company there when you say no mention of cash. If I provided one receipt that didn't amount to what you would think was roughly equal, the rest of it is cash.
Well, did you in your declaration, sir, that was filed in this case, did you tell the court in that declaration that the expenditure that you had provided on behalf of Ms. Willis was paid for back by her in cash, yes or no?
I believe that I did when I said that the expenses were split roughly evenly.
If you could point to me any place in your affidavit where you used the word cash, I would appreciate it. Take your time.
I didn't use the word cash. No, sir.
No, you didn't use the word cash, did you?
But I didn't say that she didn't give it to me in cash.
No, you just didn't tell anybody that you allegedly got paid back in cash, right?
No, I told everyone who asked.
Today.
Yes, sir.
Now, who else was with you, if anyone else, when you and Ms. Willis were discussing how you would be handling the financial component of the motion here today, that is the personal benefits?
I'm going to object to the relevance of that, Your Honor.
Mr. Gillen?
Well, the relevance is if they know that they're going to be called as witnesses, they've been subpoenaed, and they are discussing what they're going to say, we need to know that. The court needs to know that. It goes to the veracity of Mr. Willis and, Ms. Willis and Mr. Wade.
Overruled.
We didn't discuss how we were going to handle testimony.
My question was, when you were discussing with Ms. Willis in the conference room, when you were discussing what you perceived to be the situation concerning the benefits for the payments,
Yes, sir.
was there anyone else present?
No, sir.
How long did the meeting take?
Probably 5 or 10 minutes.
Did Ms. Willis tell you what she was going to say?
No, sir.
Did you ask her whether she had any bank withdrawals that would corroborate the assertion that she would pay you back in large sums of cash for these trips to the Caribbean, Belize, California, on and on and on?
Your Honor, again, I object. The proffer, when the last relevance objection was made, was that Mr. Dillon needed to know who else was there. These could be potential witnesses that he could cross-examine. That question has been answered. So I didn't object.
Okay. I think it's still exploring possible bias or motive to shape his testimony, so overrule on that ground.
Thank you. Now, Mr. Willis, Mr. Wade, when you were having this discussion, did you ask Ms. Willis, do you have anything to support these cash withdrawals?
No, sir.
Did you ask her where she got the cash?
Here, this is the conversation. I produced my credit card statement that showed what Ms. Merchant in her filing was representing. That was the conversation.
Okay. So when she would pay you back in cash, were you aware of what her financial situation was? Do you know what?
No, sir.
Your Honor, I object to the relevance.
Well, Your Honor, it's relevant because we've been bombarded with the book, Find Me the Votes, in which...
What's at issue is the financial benefit, and if that plays a material interest in an actual conflict of interest, so I think that's relevant.
Thank you. Now, have you read the book, Find Me the Votes?
I have.
You have?
I have.
Okay. Now, in that book, Ms. Willis is telling the authors about how financially destitute she was, or kind of hitting down on the bottom as she was running for DA. Do you remember that part of the book?
So let me qualify the response. I've read the book in parts. I hadn't had the time to sit and read the book in its entirety.
Did you read that part about how she's telling the authors about how little money she had and how financially she was in bad shape prior to when she was running? Did you read that part?
No, sir.
Did you ever have discussions with Miss Willis about her financial situation, which was apparently in rough shape prior to her being elected DA?
No, sir. Ms. Willis made it clear that her financial business was just that. It was her business. I know nothing about her financial status. I know nothing about how she was faring before or after the election, or even now. I know nothing about her finances.
Telling us that she didn't share that with you, but chose to share it with the authors of a book that's been published and printed and sold nationally.
I think that's a fair question for Cross.
I don't know that she shared it with the author. I don't know that the author was telling the truth. I don't know the author, so I don't know, sir.
Okay. Now, did you give an interview to the authors of that book?
I've given no interview, sir.
So you haven't talked to them at all, correct?
I haven't talked to any media.
All right.
None.
Now, as it relates to the,
I'd like to, though.
as it relates to, again, from your bank records that you're aware of, there'll be no cash deposits, right?
I didn't say that.
Are there cash deposits which line up with the money that you have allegedly received from Ms. Willis to, quote, pay you back for her part of the trips?
So here's the thing. In my bank records, you will see cash deposits. You will see check deposits. I can't say that you look through the bank records and you won't see cash deposits, because I have two sources of income, sir. Income comes from my private practice, my firm, and income comes from the contract here with Fulton County. During the course of private practice, occasionally I will have occasion to deposit cash into my account.
And in preparation for this hearing and your testimony, did you go through your bank records to find out if you could locate any cash deposits that would corroborate your testimony?
No, sir, I didn't go through my bank records at all.
Now, so what you would do, the money that you received, of course, the money that you received from your work for Fulton County, that's public funds, correct?
No, sir, that's private funds. It's my
Public funds pay you to do work for Fulton County, correct?
Tell me what the definition of a public fund is.
A public fund would be funds, as in not fund, but funds, money. Public money, as in money from taxpayers, either in Fulton County or the state of Georgia, pay you to do the work that you're doing here in this case, yes or no?
One or the other, I'm certain.
You know which
is
one?
the case. I don't know which one, no, sir.
Now, you would take those public funds, and those public funds were then used, deposited in your account, and they were then used to pay on the credit cards for the trips that you would take with Ms. Willis, correct?
I object to the question insofar as the characterization of public funds. The witness didn't testify to that, and I don't believe there's been any evidence to that. Once it's paid to Mr. Wade, it's private funds.
Well, the point of it is that you got
All
money.
right, Mr. Gillen's rephrasing.
Yeah, I'll read it. Let's break it down. You got money from Fulton County for the work that you do here, right?
Yes, sir.
You would send in invoices, and they would pay you money, correct?
Yes, sir.
Those money, that private money, that money was money from either the citizens of Fulton County or from the state of Georgia, correct? That's what I mean by public funds. Agreed?
But I guess I'm having trouble with the notion that the citizens of Fulton County have paid me any funds. I'm not certain the funding source. I can tell you that either the state of Georgia or Fulton County has written me a check.
So that would be, those two entities are public entities, correct?
Yes.
So that would be public funds, right? Right? Yeah.
Yes.
And those public funds are from the same source that you would then use to pay out on your expenses for the trips that you took Ms. Willis on, correct?
No, sir. As I testified to moments ago, I have income coming in from my law firm. I also have income coming in from the funds that we're here discussing now from either the state of Georgia or Fulton. Certain what it is. So
What
to
percent?
say
Sorry,
that
I didn't mean to cut you off. Go ahead.
So to say that I'm paying a credit card statement with funds coming from Fulton County or the state of Georgia would not be an accurate statement, because the funds could have very well come from my private practice.
What percentage of your income in 2022 came from money where you're working on this case or from your partners working for the Fulton County office?
In 2022, I would say 50-50.
You think 50-50 in 2022?
Yes, sir.
What about 2023?
Probably 60-40.
60-40?
Yes, sir.
So the money that would be in those accounts, at least 60% of those, in your view, would be public funds, that those monies were then used to pay for the expenses that you had incurred for the trips that you took Miss Willis on, the cruises, the Napa Valleys, the Bahamas, correct? Right?
Yes, sir.
Okay. And now, what you did is that when you signed on in November 1st of 2021, that's when you signed on to be counsel for the anti-corruption matters, right?
Yes, sir.
Now, as you know, in your engagement letter, it doesn't say that you're signing on in your scope of work is to work on the Trump special grand jury investigation, doesn't.
No, sir.
It says that you're signing on to work on anti-corruption, the anti-corruption unit matters, correct?
Yes, sir.
Matters with a plural, correct?
Yes, sir.
So in your contract, there is no specific reference to any specific case. Isn't that right?
That's correct.
Okay. Now, but you didn't sign on for the duration. There was a period, you have a contract, and then it would then expire, and then you would have a new contract, correct?
Yes, sir.
Now, of course, the extension that you received, the first one was in November of 2021, and then you filed, there was a renewal in November the 15th of 2022. Is that right?
Sounds right.
Oh, okay. Now, that was right after you got re-upped by Miss Willis, right after you took Miss Willis to Aruba. Isn't that right? On that November the 1st, 2022 trip to Aruba and through November the 4th, 2022. Correct?
What does re-up mean?
Well, re-up means that you came back, your contract was up, and then on November the 15th, you and Miss Willis signed a new contract for you, right?
Yes, sir.
Okay. Now, when you were in taking her to the Aruba and on the cruises and the resort there, did you discuss your re-upping of signing an extension on your contract?
No, sir. But you make an excellent point. I'm glad you pointed that out. So the trip to Aruba, the contract was not in existence then.
So you're saying that you were not
Under contract.
in your contract. Did you send any invoices in for work that you did after your first contract expired?
No, sir.
You did.
No, sir.
No. When that expired, that was it. So and then you're saying that after the Aruba trip, you get re-upped with a new contract, correct?
I signed a new contract. Yes,
Now,
sir.
was there any modifications on that contract? Did you get an extension on the cap that you were limited on the first one? Were there any modifications at all, Mr. Willis? Excuse me. I've done that again. I apologize.
I've been called worse.
Wait, I'm sorry.
I've been called worse.
Now, were there any modifications on that?
Do you have the contracts in front of you where you could?
I don't have it in front of me, but I think that Birch is going to.
Because I believe as the work gradually, as the time of the work gradually increased, the hourly cap would increase. In other words, starting out the investigation, it was impossible to anticipate the level of cooperation during the course of the investigation from some of the witnesses. So if you assume that there would be great cooperation with the witnesses in terms of interviewing and speaking and being voluntarily speaking with you, it doesn't take as much time. So after getting into it, realizing that most of the witnesses were not willing to speak or willing to turn over evidence or information, quickly you figure out that this is going to take a little more time than originally anticipated. And because of that, you have to compensate for those hours.
That's why there was a compensation on your extension?
Yes, sir. The caps.
A cap. Now, did Miss Willis review your invoices with you when you would submit them?
Never.
Did anyone ever question whether or not you worked 24 hours in one day and billed 24 hours in one day?
I've never worked 24 hours in one day and billed 24 hours in one day.
Okay.
And I'm glad you asked me that question because I'd like the opportunity to talk about that.
I think you should go ahead.
So if you look at that invoice where it says 24 hours in one day, it actually doesn't say one day. If you look at the top of the invoice, it says date completed. The date that's reflected on that invoice reflects the date that the work was completed. It doesn't say when it started. It just says this is the date that is completed. So if you go through the invoices, probably around the first 5 or 6, you'll see that that's the billing format. I would bill only after that particular task has been completed. That's why you see a 24-hour period with the one day there. I kind of wish some of the experts who had opined on that had called me and asked me the question, but there was never a billing of 24 hours in one day. Now, probably around the 6th or 7th invoice, you see the format changed. I started using a range so that it got less confusing, right?
I'm confused, so maybe you can correct it.
Okay.
In Exhibit 14, you've got down a specific day.
Mm-hmm.
Prepared cases for pretrial, November the 5th, 2021, 24 hours at $250 an hour, 6,000. Now, this wasn't about a range. It was about the work that you did on November the 5th, 2021.
No, Mr. Gillen, look at the top of the invoice where it says date completed.
What I want you to do, Mr. Wade, is focus on the date that you have down there and tell the court what you billed for on November the 5th, 2021. I thought it was already in. I thought 14 is in.
Again, Mr. Gillen, it says completed date completed. The dates that you see here are the dates that work was completed. So on November the 5th, I completed the task of preparing the cases for pretrial. That's the date I completed it.
Just
then
read,
it took me.
Just read if you would. Then my question was, read out loud the entry for November the 5th, 2021, and how many hours you billed that day. Just do that for me if you would.
I can't do that.
Excuse me, I believe the witness is entitled to answer his question. That certainly wasn't the question that Mr. Williams asked.
All right, well, the question now is to read a certain entry. So.
Just read into the record, Mr. Wade, on November the 5th, 2021, how many hours did you bill the citizens of Fulton County for on that day? Just read it out, please.
I completed the task on November 5th, 2021. 24 hours was billed at $250.
Now, when you talked about your relationship with Ms. Willis, and your testimony is that it began in 2022. Do you remember that testimony?
No, sir. Our relationship began in
Your romantic
2019.
relationship began in 2022?
Yes, sir.
That's your testimony?
Yes, sir.
Okay. Now, when you were re-upped on this contract, you had a romantic relationship already established with Ms. Willis, yes or no?
In 2022?
You know, when
Yes,
you were
sir.
re-upped on November the 15th, 2022, you had a romantic relationship with Ms. Willis.
I signed the second contract. Yes, sir.
Answer my question, please.
I'm not going to use the words re-up.
Signed up on we re-up or whatever you want to call it, your contract on November the 15th, 2022, you had a romantic relationship already existing with Ms. Willis, yes or no?
I signed the contract, the second contract, yes, sir, during the course of a romantic relationship.
Yes or no, you had a romantic relationship with her at the time that you signed up the extension on November the 15th, 2022, yes or no?
The answer to that question is yes.
Thank you. Now, this was before the special purpose grand jury released a report, isn't that correct? Correct?
Are you asking me if it's before the work was completed or before the special purpose grand jury actually publicly released the report?
When they
Those are
released
two
the
different.
report. Your relationship with Ms. Willis already existed when the special purpose grand jury released its report, correct?
At the time the report was released, yes, sir. But
And-
you understand that the report, the work had been completed prior to the release of the report. You understand that?
And your relationship with Ms. Willis, of course, was prior to the indictment in this case, correct?
Yes, sir.
Your Honor, if I may just ask my folks over here whether there's anything I need to clean up on. That's all the questions, Your Honor, I have. Thank you.
Your Honor, I do have a question.
Well, I don't think we went through.
No, I had asked him for permission, that he was going to go first on this, and then I was going to follow up. That's the deferment, was to allow him to go first. That's what I thought I had asked for.
All right, with the understanding next time, we're going to keep going in order and not skip around the order. All right.
That's why I brought it up, because I thought that's what
Okay.
I was intending.
All right. Mr. Sato.
I'm going to try to keep my questions very specific.
Yes, sir.
Okay?
Yes, sir.
And I'm going to also, of course, try not to go back into specific questions that have already been asked. Okay?
Yes, sir.
When did your relationship with Miss Willis end?
2023.
Can you give us an approximation of, not by date, but by month?
Summer 2023. Forgive me. I'm a man. We don't do the date thing. Summer 23, I would say June, maybe.
Okay. Using the euphemism personal relationship, did you have any personal relationship at all with Miss Willis after the summer of 2023?
I want to make sure that I'm answering your question. Are you, because
Let me rephrase, if I might. The way it has been characterized in, for example, the response of the state, and I believe in your affidavit, is there's a difference between a personal relationship and a professional relationship. Correct?
yes, sir.
Okay. I'm not talking about a professional relationship. I'm talking about a personal relationship. Have you had a personal relationship at all, and you know what I mean by that, after the summer of 2023?
Are you asking me if I had intercourse with the district attorney?
I was trying not to, but I guess if you're going to characterize it as that, the answer would be
The answer would be no.
so. It's been purely professional since the summer of 2023.
So that's where we're having issues.
Okay, you'll have to explain because I don't know what the issue would be.
No, I will explain to
Thank
you. You say personal. We're very good friends, probably closer than ever because of these attacks. But if you're asking me about specific intercourse, the answer is no.
How about if I change it from intercourse to romantic?
No.
Okay. During the direct examination, you made a statement, at least I believe I heard it correctly, that personal relationship, and now I'm talking about that characterized the sexual romantic relationship, was not a secret. Is that correct?
Wait. If you're asking me if people knew that we were having sex, no, they didn't.
I'm asking you whether the people knew that you were dating, whether you were romantically involved. You said that it was not a secret.
Oh, it wasn't a secret. It was just private. My mother knew, obviously.
Did anyone in the district attorney's office that has worked on this case know that you were dating or had a romantic relationship with District Attorney Willis?
I don't know what they knew.
Well, did you tell anyone?
No,
Do you have any knowledge of whether Ms. Willis revealed it to anyone?
I have no clue.
Okay. So as far as you know from personal knowledge, no one in the DA's team knew, correct?
That's correct.
Okay. So if it was a legitimate relationship, is there any particular reason why it was kept secret or private?
It wasn't kept secret. It was kept private.
And the purpose for that was?
It's what we chose to do.
I'm asking you why, though, not just because you chose. Why, if you're dating someone, why keep it private?
So, a few reasons. The first one is, and I want to say this respectfully in the right way, there are some people who are in the public eye who just don't like it, don't wish to be there. I have tried to have lunch or dinner with her publicly, and I can't count the number of people that would approach the table or would accost us as we're trying to walk into a restaurant and just have lunch or have a meal. It is not secret. It is private. We don't want the world asking questions or interrupting that time. So we weren't trying to keep anything a secret, Mr. Sadai. There's nothing secret or salacious about having a private life. Nothing.
I'm not suggesting that there was. I'm asking the questions. When you went on the various trips that have been outlined by both Mr. Gillen and by Ms. Merchant, did anyone in the district attorney's office know that the two of you were traveling on personal trips together?
To my knowledge, Mr. Sadai, no.
Okay. And again, that was for privacy, according to your testimony.
Privacy, yes, sir.
Okay. Did you and Ms. Willis go to the Hapeville condo prior to your relationship starting the beginning of 2022?
Prior to having physical contact, prior to having intercourse, did we go to the Hateville condo?
Again, you keep going to intercourse. I'm trying not to, but fine. The answer to that, my question would be yes. Did you and Ms. Willis go to the Hateville condo prior to what I want to say November 1st of 2021?
Yes.
Okay. And the purpose for going to the Hateville condo with Ms. Willis prior to 2021 would have been what? Or prior to November 1 of 2021?
Could have been any number of things, because at that time,
That's what I'm asking. So tell me.
yeah, could have been any number of things, because at that time, she had a friend living in that condo. Miss Yurdy lived in that condo.
Okay. Maybe it was my question was poorly worded. Let me try again. Your answer is yes, prior to November 1st of 2021, you would have gone to the Hateville condo and been there with Miss Willis, correct?
Yes.
And you would have been there, as you indicated, for many reasons, right?
Yes.
Can you give me, just list a few of the reasons?
Miss Yurdy resided there, went to visit her, maybe went to talk about a document that I received.
You would go to the condo
I
to talk
needed
about
to
a
see.
document that you received?
Absolutely.
Okay, go ahead.
Absolutely.
Any other reasons?
None come to mind.
None come to mind?
No, sir.
And would you say that was frequent? When I say frequent, do you think prior to November 1st of 2021, you were at the condo more than 10 times?
No, sir.
So it'd be less than 10 times?
Yes, sir.
So if phone records were to reflect that you were making phone calls from the same location as a condo before November 1st of 2021, and it was on multiple occasions, the phone records would be wrong?
If phone records reflected that, yes, sir.
They'd be wrong.
They'd be wrong.
Okay. Where did you live during that time period?
The same place I live now.
Which is not in Hateville, correct?
It is not in Hateville.
It is north of Atlanta, the city of Atlanta, correct?
It is.
Okay. And any other reasons why you would be in the Hateville area on multiple occasions prior to November 1st of 2021?
Let's see. The Porsche experience is there.
I'm sorry?
The Porsche experience is there.
Okay, so that would have been one. Any other reason?
Yes, sir. The airport is there.
Airport in Hateville.
Yes, sir. Delta Airlines is
Okay.
headquartered there. Let's see. Restaurants there.
Okay. If that's your recollection, that's fine. I'm not asking you to try to remember everything, but if that's
okay.
Okay. Did you discuss your affidavit filed in connection with the response with Ms. Willis?
No, sir.
Did you know, personal knowledge, whether Ms. Willis reviewed your affidavit before it was included with the response?
I have no clue.
So as far as you know, personal knowledge, Ms. Willis did not know what you said in the affidavit.
I did give it to her.
That's what I said. You have no personal knowledge.
No personal knowledge.
And as far as you know, no one else has told you that she did or didn't.
I hadn't asked anyone.
We've kind of worked this up a little bit, and the numbers could be off. But according to our numbers, $10,000, give or take, would have been reflected on your credit card statements in connection with things of potential benefit to Ms. Willis, okay? I want you just to assume that. Assuming that there was $10,000 that you had on your credit cards, is it your testimony that Ms. Willis paid you back $10,000 in cash? I'm not asking about...
Object. The characterization of $10,000 for Ms. Willis's travel, I don't believe is an accurate reflection of what the numbers, at least the summary that I've been provided by the defense would reflect. I think that's joint travel. Is that right, Mr. Sater? I'm sorry.
No, it's not joint travel. But all I'm trying to understand, I'll rephrase because I don't want to get bogged down on specific numbers. You would have received thousands of dollars in cash from Ms. Willis, correct?
Yes, sir.
Okay. And the thousands of dollars in cash from Ms. Willis, do you know, I'm not asking you whether she took it out of her pocketbook or she took it out of a suitcase. I'm saying, do you know the source of the cash?
Just that, out of her pocketbook. Yes, sir.
You don't know where she obtained the cash.
I didn't ask her.
And the whole time that she was paying you in cash, you never said, hey, why do you have this amount of cash?
Why would, Mr. Sadow, in my practice, people come into my law firm all the time with cash. I never question where they got it.
Yeah, but we're talking not about people that come into your law firm. We're talking about the district attorney of Fulton County, who I'm assuming receives a paycheck. She doesn't get paid in cash.
So just like you assumed, I assumed she got it from her paycheck. I don't know.
Okay. But of course, it's already been, and I'm not going to go back into it. You've not seen any records indicating withdrawals of cash from Ms. Willis at all.
Why would I ask her?
I didn't
No,
ask.
sir.
All I said is you haven't, right?
No, sir.
Okay. Now, can you explain why you filed for divorce one day after you were hired by Ms. Willis. You filed on November 2nd of 2021. You're hired on November 1st of 2021. Why the day after?
You mean one day before? So,
You filed for divorce one day after you were hired, right?
okay, I'll answer your question.
Okay, please.
So in 2015, when my wife had the affair, we had a conversation that we would divorce right then. Again, the better practice, at least for my children at the time, was to stay in place until the youngest could graduate and matriculate into college. We did that. When she graduated, matriculated into college, at the time my wife had moved back and forth to Houston, to Texas. So she's in Texas. We take our child off to college. We come back to Georgia for a brief period of time. Divorce gets filed. She gets served. There we go. Now, the reason that date was selected.
Yes, sir. That's what I asked.
The specific reason that specific date was selected was because she was only in town for a brief.
Your Honor, this is attorney-client privilege. Why he decided to file this?
And why do you have the right to object on his behalf for attorney-client privilege?
Because
Well, I don't make formal.
All right, there we go. And
I believe that he's already attempted to answer this question, and there was no privilege raised. So he's given a partial answer, and now he's about to finish that. So first of all, I don't think it's covered by attorney-client privilege, and I'll deal with that if you want me to. But otherwise, he's already answered part of it. So he doesn't get to say, now I'm going to stop. So
well, it was a long preface, but I don't think it ever actually got to what might have been at issue there. So if you can lay the foundation, we'll deal with the objection.
okay. Take a step back. Okay. You realize that an attorney-client privilege is the privilege of the client, correct?
Yes, sir.
And you, in connection with your representation, at least it's been proffered to the court by Mr. Bradley, that it's up to you to decide whether you want to raise the privilege, right?
Yes, sir.
It's not up to Mr. Bradley.
Yes, sir.
So you have the power, in order to get to the truth of the matter, you have the power to waive the attorney-client privilege, do you not?
I believe that's an inappropriate question. The privilege is there.
Whether he uses it or not, it doesn't matter why. Mr. Sato, I think if we're trying to get to the answer to your question, let's figure out whether it covers the question you were trying to get to.
And if I may finish, and your position is you have no intention of waiving your attorney-client privilege, correct?
That's correct.
All right, so now, can you answer the question why you waited until November 2nd, the day after you were hired by Ms. Willis, to file for divorce?
I can.
Okay.
So, again, Joycelyn had relocated to Texas, and she had been in Texas for months. She was only here for a brief period of time to drive my daughter's car back with her. And when she came here to do that, I was able to then get her served.
Okay, so your answer as to why you waited until the day after you were hired by Ms. Willis, which would be November 1st, 2021, to file the complaint for the divorce on November 2nd, 2021, your testimony under oath is because your wife was here. But had not been here in October, had not been here in September, had not been here in August of 2021.
She had been in Texas taking care of her ailing mother
So
and
your
an
testimony-
aging father. So the first opportunity that I had after speaking with my lawyers to take care of that was the date it was filed and served, because she happened to be here. It had nothing to do with, that was purely coincidental, that contract.
I understand it's purely coincidence, your testimony.
Yes,
My
sir.
specific-
And understand that this was by agreement between she and I, she being my wife and I, that we would divorce when the children matriculated out, and that there would actually have been an agreement attached to the filing. It became apparent that the agreement wasn't going to happen, and things got a little contentious. So that's when the privilege will kick in, and I was forced to do it when I did it.
Okay. So, if I understood correctly, again, you tell me if I'm wrong. Is it your testimony that your wife was not in Atlanta, Georgia, or the metro area throughout October of 2021?
No.
That's not your testimony?
In October of 2021, she was back and forth between here and Texas.
So she was, at least on some occasions, in the Atlanta area.
But that was during the time when we were working through the consent agreement that fell through.
Again, I think we're pretty far afield on relevance. The answer to the question about the timing of the divorce filing. and-
Understood, Ms. Cross. Ms. Sato, where are we going from here?
We're about to finish this area, since I'm not going to be able to go any further about, if we want to call the X, we'll call the X for that purpose.
Well, we're going to have to discuss whether that's a collateral issue altogether.
No, I'm just saying if. I didn't say we will, but we'll.
Okay.
All right, so you said that you were aware of the contracts that Mr. Bradley and Mr. Campbell had with the Fulton County District Attorney's Office, correct?
Yes, sir.
And how did you become aware of those?
Just through conversation, they
With
told
who?
me.
Conversation with who?
Mr. Bradley and Mr. Campbell.
So you were discussing matters with Mr. Bradley which were not related to attorney-client privilege, correct?
Related to the contract, yes.
Okay, but you were having conversations that would not, even though, if I understood correctly, Mr. Bradley was your attorney at the time, correct?
At what time?
At the time that Mr. Bradley received his contract from Fulton County, which would have been beginning of January or in January of 2021, right?
Is that the date of his contract?
Pretty close.
I don't know what the date of his contract was, but if
Date for
it
my
was
purpose-
after the date of the filing of divorce, then yeah.
I'm not talking about after the date of the filing of the divorce. It's been represented to the court that you had an attorney-client relationship with Mr. Bradley from 2015 forward,
Yes,
correct?
sir. Yes, sir. That is correct.
When Mr. Bradley received his contract with Fulton County, that was in 2021, correct?
I don't know.
We can prove that through other evidence. But at the time that Mr. Bradley was doing work for Fulton County, if I understand, you still had an attorney-client privilege, at least you're claiming one, with Mr. Bradley, correct?
Yes.
Okay. So when you talk to Mr. Bradley about matters with his contract in Fulton County, those were not covered by your attorney-client privilege, correct?
They were not.
Okay, and that meant that not all communications with Mr. Bradley were covered by attorney-client privilege, correct?
Well, those certainly weren't.
Well, but my question was, not all communications with Mr. Bradley were covered by, at least as you've been represented to the court, by the attorney-client privilege, correct?
Those communications were not.
So there were communications outside of the attorney-client privilege, correct? With Mr.
Yes,
Bradley.
If you're asking me if I ever communicated with him outside of the attorney-client privilege, the answer is yes. I
Okay.
communicated with him outside the attorney-client privilege.
Let's finish this up. And did you call it Roman number 4? Or just defense? Okay. In defense exhibit number 4, and Mr. Gillen went over with you your responses to certain interrogatories on May the 30th, 2023. Remember that?
Yes, sir.
Not going back into those. The words in the interrogatories are already in evidence, so we're not going to do that. But the ones that we've gone into, there were 2 of them. And your answer to both of those was none, correct?
Yes, sir.
Okay. Now, on January 25th of 2024,
Yes, sir.
you again were in a position that you answered those same interrogatories, the 2 that we're talking about. I can get specific if we need to, but as long as we understand we're talking about the same 2,
Yes,
right?
sir. Yes, sir.
Okay. And they are in defense exhibit number 6, and they are interrogatories number 4 and number 5.
Okay. Go ahead.
No, I want you to be able to see it. So it's a defense exhibit number 6.
I don't.
See, you have 6 up there? I'm told that you have 6.
Okay. Here we are.
Okay. You would agree with me that in defense exhibit number 6, and we're talking about interrogatories of January 25, 2024,
Yes, sir.
that as to interrogatory number 4, that's the same interrogatory, same words that were in the interrogatory that Mr. Gillen went over, which was dated May 30th of 2023, correct?
Yes, sir.
And your original response in defense exhibit number 6 was none, correct?
Yes, sir.
Your updated response was, the plaintiff declines to respond to this interrogatory and asserts his privilege pursuant to OCGA section 24-5-505, correct?
Yes, sir.
You know that 24-5-505 breaks down into two privileges, right?
Which is why I was specific. I said I asserted the privacy privilege.
Well, that's what I'm asking you. In your updated response, there's no reference to privacy, correct?
Yes, there is in the code section 24-5-505.
Okay, but it also-
reference to privacy.
Just go with me, okay? That code section says, does it not, no party or witness shall be required to testify as to any matter which may incriminate or tend to incriminate such party or witness, or which shall tend to bring infamy, disgrace, or public contempt upon such party or witness. You'd agree with that, right?
I'm not reading it.
I'm sorry?
I'm not reading it. I don't have it in front of me.
if I may.
Mr. Sato, we can, I can take judicial notice that is what the rule says if you want to ask him any follow-up questions.
Okay, thank you. You are not claiming that your answer to number 4, interrogatory number 4, on January 25th, 2024, incriminates you, that is, as in Fifth Amendment privilege, right?
That's correct.
You're claiming the second part, that it would bring infamy, disgrace, or public contempt, correct?
I'm going to object to that. I don't think that's the full thing, but and also the witness doesn't have it in front of him, so I don't know how he could respond to that. He said several times privacy is largely invoked that statutory.
Overruled.
I'm claiming privacy.
The privilege that you make reference to is to infamy, disgrace, or public contempt upon the witness, right? Or party. That's the section that you were relying on, correct?
If that's what it says, yes, sir.
Okay, look. I could show you, but I think the court has already indicated he can take judicial notice of the statute. So assume that what I'm telling you is accurate, okay?
Yes, sir.
Okay. How would an answer of none bring infamy, disgrace, or public contempt upon you?
So, as I explained in direct of Mr. Roman's counsel, the minute she elected to intervene into my divorce proceeding, I then started to understand the bigger picture, which was that all the attorneys in the election interference case were colluding with Joycelyn's divorce lawyer. And because of that, I said, privacy. I don't want my divorce proceeding to bleed into this criminal proceeding. I just didn't want that.
So you raised a privilege, if I understand, that indicated that your answer would bring infamy, disgrace, or public contempt upon you, right?
Your Honor, I'm going to object to the relevance of this and ask and answer several times.
Mr. Sato, where are we heading with this?
I think I can finish that up by saying you didn't say none again. You asserted a privilege, correct?
That's correct.
Okay. And you did the same thing, did you not, with number 5?
That's correct.
That is, you didn't say none again, right?
Correct.
Okay. Is the answer to the interrogatory number 4, if you have it in front of you, is the answer none? Is that the truth?
The answer is, to that interrogatory, is as I placed it at the time I responded, sir.
I'm
That's
asking
the
you
answer.
now, is the answer to that interrogatory
The answer
none?
is, the answer is still privilege.
All right. So he's apparently electing to apply the same privilege, Mr. Sato, to that exact same question.
And I have a case which indicates that we can get beyond that if the court deems that appropriate.
And to what end? To what end?
That the privilege actually does not apply and he must answer the question.
And where does that get us? Even if he answers the question. Hasn't he already kind of said everything he has to say about the nature of the relationship, how long it lasted, when it ended?
No, I think it would prove, I think if he is forced or compelled to answer the question, he will either answer it falsely by saying none, or he answer it truthfully by saying yes and then telling us what it is. That's what I believe. That's why I'm asking.
But the interrogatory you're referring to, though, the question contained there,
Two interrogatories, yes, sir.
it's the entertaining one, it's whether there were other relationships, right?
With a specific language that's in the interrogatories.
Sure. Haven't we already covered that in all the other questions that we've had so far?
But we have, but again, the court could, if I could require or compel an answer from him as to whether his answer would still be none, then we would know whether or not he was telling the truth now. If the answer is no, then obviously there was a time in the past where he was not. It simply requires him to now answer under oath what he refused to answer and claimed, what I might suggest, is a bogus privilege, and that you can pierce that privilege because it's a material fact in connection with this case. Again, it's a call that Your Honor makes. I have case law that says you can do that, but it's your discretion.
Ms. Cross?
Your Honor, Mr. Petition ran now for several hours. He's been asked and answered very personal questions. I believe cover the issues. Mr. Sato is making an argument, and this is probably an argument to make for the later to the court and not a question to propound.
So as I see it, the only relevance these interrogatories have to this case really whatsoever would be as either prior inconsistent or consistent statements. And to that end, I think the question has been put to him again and again and again. He's answered how he believes he felt his answer should be and why he answered a certain way. And as it goes to credibility, I think at this point we're arguing weight, and I don't really see the value in pushing this issue further. So,
All right, well, just for the record, the case that I was going to refer to is State versus Wakefield at 324 Georgia Appeal 587. And specifically, let's see, it would be 590, in which they talk about this specific privilege. This is a 2013 case. And then they footnote to number footnote 3. And footnote 3 says there are times when the materiality of the evidence outweighs the testimonial privilege. And it goes and explains what that is. That's what I'm bringing up.
And I see what you're saying, that we could say that you need to answer the question regardless of the privilege you asserted. At this point, though, I think we've covered that ground and we're ready to move on.
Okay. Based on that, I have nothing else. Thank you.
Okay. Mr. McCulloch, anything? On behalf of Mr. Floyd. Moving through defense counsel.
Oh, I'm sorry.
No, looking behind you.
I
Mr.
thought so,
McCulloch,
okay.
on behalf of Mr. Floyd, he's elbowing you, sir. Okay. Mr. Cromwell.
Nothing, Your Honor.
All right. Ms. Cross.
Thank you. Mr. Wade, have you still got exhibit number 14 in front of you? That's the one with all of the invoices, I believe.
I believe I have them all.
All right. So you were asked, Mr. Wade, about a couple of the invoice items. And your testimony, I think, was that the percentage of income post special counsel appointment in November 2021, the percentage of your income roughly after that time was about 50-50, Fulton versus other income from your law practice, correct?
Roughly, yes, ma'am.
Okay. Sometimes more, sometimes less?
Yes, ma'am.
All right. How about your time? I'm interested in the percentage of your time from November 2021 to, let's say, the close of the special purpose grand jury when it was dissolved in January 2023. Can you estimate for us the percentage of your time that was spent on Fulton County work versus other work?
Oh, gosh. 99% of the time here in this building working on this case.
All right. It was, as I understood your testimony, it was an intense period in terms of hours while that special purpose grand jury was meeting, correct?
Yes, ma'am.
And who was head or manager of the election integrity case during that time for the district attorney's office?
I was.
You were coordinating the efforts?
Yes, ma'am.
And those efforts included not just the proceedings that were happening in this building, correct?
That's correct.
We don't need to go all through it, but is your representation that 99.9% of the time, let's restrict it to 2022, 99% of your professional working time was devoted to this case?
Yes, ma'am.
And the remainder, whatever it was to some of your other cases that were ongoing?
Yes, ma'am.
All right. 2022, I want to focus on that a little bit because if we are looking at, I believe, the financial affidavits, do you have those in front of you as well?
I do.
The financial affidavit that was filed in your divorce case in January 2022, you estimated your monthly income at that time was $14,000 a month, right?
In 22?
January 22.
Yes, ma'am.
January 23, what'd that number come to?
9,000.
What about 2024?
I don't know.
Is that there in front of you? Is that one? That's not one of the ones that's there in front of you?
No, ma'am.
All right. So as reflected in those financial affidavits, your income decreased as a result of your work in this case, correct?
Significantly.
The structure of your firm, we talked a lot about that, and I don't want to go through it anymore, but than we need to. But 2022, the structure of your firm changed. Is that correct?
That's correct.
All right. In the early part of 2022, there were three of you. You and Mr. Campbell and Mr. Bradley, you split expenses. Is that right?
That's correct.
And you profit shared among yourselves, correct?
Correct.
Right. After Mr. Bradley left the firm, then there were just two of you, correct?
That is the cause of the significant change. Yes, ma'am.
So now you have two people bringing in income, correct?
Correct.
And one of those people, you, is spending almost all of your time devoted to this election integrity case, correct?
Yes, ma'am.
Right. And your income from this election integrity case is less than what it was the year before.
Yes, ma'am.
We talked about the monthly caps, or we didn't talk about it. There was talk about the monthly cap that was included in your contracts, indicating there was a certain threshold that you could reach, number of hours a month, and over that amount you were not going to be compensated, correct?
That's correct.
All right. And you kind of smile when you said that. That's a little bittersweet there, isn't it?
That's bitter.
All right. Exhibit 14, is that still there in front of you?
It is.
I want you to take a look, please. That's a collection of exhibits that includes all of your invoices, as was represented. I want you to take a look at invoice number 9.
Yes, ma'am.
Is that there in front of you?
I have it.
Invoice number 9, Mr. Wade, indicates that you performed hours of work that you were not compensated for because your cap had been reached.
Yes, ma'am.
I want you to take and what did you do in those circumstances? When the hours that you worked per month were more than the cap that was in your contract that you were permitted to be paid for?
I was forced to lose that time. I didn't get paid for it.
Okay. And that's what exhibit number 9 shows?
Yes, ma'am.
All right. And in exhibit number 9, you've got a task, hours that were completed, and you just didn't bill for it. You noted the time and then a zero beside it because you didn't bill the county for that time.
Yes, ma'am.
All right. What about exhibit number, invoice number 13? Can you flip to that for me?
I have it.
Is that a similar situation?
Yes, ma'am, it is.
And what is it on exhibit, invoice number 13?
This invoice makes me cry. There's so many hours here that I worked that I couldn't get paid for. So,
And you work those hours anyway, Mr. Wade?
oh, absolutely. This is not the type of job that you could walk away from just because you're not getting paid for it. I think there's some professional rules of responsibility to an attorney who's engaged in a case. You have to see it through. So it's not like I can just throw my hands up and say, well, I reached my monthly cap, I'm done. I can walk away. I can't do that. This is ongoing. It's constant, and I have to do the work.
Can you look at invoice number 23 for me there in exhibit number 14?
Yes, ma'am.
Does that reflect a similar situation, hours worked that you were not compensated for?
Yes, ma'am.
Invoice number 24 and 27, can you take a look at those and let us know if that reflects the same situation?
Are you trying to depress me?
No,
Looking
no.
at the money I'm
sorry.
It's the same, yes.
Okay. And there's no workaround to that? You didn't attempt to work around that contractual cap on your hours?
Oh, no, ma'am.
All right. You were asked a lot of questions, Mr. Wade, about that affidavit that was submitted, correct? Do you recall those questions?
I'm sorry, I'm stuck on this invoice. You know, if I was going to get a benefit, I'd like that benefit. That's the one I want. That didn't happen.
That didn't happen?
Okay.
All right. And there was no renegotiating your contract to reflect that those hours should be paid or anything?
No, ma'am.
Okay. All right. Do you have your affidavit there in front of you?
I do.
The affidavit, of course, was attached to and provided in support of the state's response to Mr. Roming's motion, correct?
Yes, ma'am.
All right. And you prepared that affidavit?
I did.
You signed that affidavit?
I did.
All of the allegations and the representations in that affidavit are true. Is that right, Mr. Wade?
Every one of them.
Every one of them. You were asked a lot of questions about our line number 34. Can you turn to that for me, please? It's on page 4 of that affidavit.
Yes, ma'am.
Can you read it out loud for me, please?
The district attorney and I are both financially independent professionals. Expenses for personal travel were roughly divided equally between us. At times, I have made and purchased travel for District Attorney Willis and myself from my personal funds. At other times, District Attorney Willis has made and purchased travel for she and I from her personal funds. Examples of District Attorney Willis's purchasing plane tickets for she and I with her personal funds for our personal travel are attached.
Funds, Mr. Wade. As you understand the term funds, does that include cash?
Yes.
Does that include credit?
Yes.
Does that include reimbursements?
Yes.
You didn't represent in your affidavit, Mr. Wade, that you were including all of the receipts from funds or travel expenses that were paid on your behalf by District Attorney Willis, correct?
That's correct.
You had, I think your conversation with Ms. Merchant was, you produced the receipt that you had.
Yes, ma'am.
Are you aware of any other receipts? Well, let me ask you this, or may I put you on there for a sticker? That's all right, I'm gonna write it on there. I'm gonna mark this as state exhibit number 1. You testified, Mr. Wade, that District Attorney Willis purchased and funded the entire trip to Belize. That was her treat to you for her birthday?
Yes, ma'am.
And you testified that she purchased the plane tickets for you, correct?
Yes, ma'am.
And while you may not have had the receipts on hand when you filled out the affidavit because they weren't in your possession, are you aware now that there are receipts and that it reflects that the district attorney?
If this is going to go into evidence, you'd like to look at it first.
I've got a copy. Do you remember, Mr. Wade, approximately how much, and that's again state's exhibit number 1, may I first look down? Do you remember how much the flight was for you, your flight to Belize? And if you don't, I'm not tendering it for you, so I'm just asking you to take a look at that and see if that refreshes your recollection as to the amount that that plane ticket cost that was extended by District Attorney. You may keep it. You keep it. Does that refresh your recollection, Mr. Wade?
It does. Thank you.
Approximately how much was the amount of the ticket that District Attorney Willis purchased for your travel to Belize?
$887.35.
And I'm not tendering it, Your Honor, but I will leave it with the court reporter for reference in the future. All right, Mr. Wade. Your testimony here in court today and consistent with your affidavit was that the personal relationship, I think we called it dating today as well, the personal or dating relationship between you and the district attorney began sometime in early 2022, March, I think was your testimony, is that right?
Yes, ma'am.
Right. And that March date isn't included in the affidavit. The affidavit is less specific, but that was your testimony today?
Yes, ma'am.
And that there was no personal or dating relationship prior to that time, right?
No.
Okay. Mr. Wade, I'm sorry. I'm going to direct your attention to 2020. In 2020, were you dating the district attorney?
No.
2020, that was during the COVID pandemic, correct?
It was.
Was there a situation for you, Mr. Wade, that made you particularly vulnerable during the COVID period?
Yes, ma'am. And in 2020, and a portion of 21, I was battling cancer. And that prevented me from pretty much leaving environments that aren't sterile. And I had health on my mind.
You were particularly cautious during that time.
Yes, ma'am.
Were you dating anyone in 2020?
No, ma'am.
All right. Thank you, Mr. Wade. That's all I have.
Ms. Merchant, recross on those points only.
Yes, thank you. All right, Mr. Wade. The state asked you about how much money you're making now versus before, and you said you're making significantly less since you started working for Fulton County, correct?
Well, I did say that, but what we're talking about is because now at this point, the splitting of the financial obligations in the firm are now there are two people carrying the weight of three. So that would scale back on the amount of income, right? Amount of profit.
Well, you're splitting the profits 50-50, though, instead of 1/3, correct?
The profits, yes.
Okay. So, but you did testify that you're making significantly less now. We heard about it for a few minutes. Significantly less now that you work for Fulton County, right?
Yes.
Okay. Would you agree with me that $236,000 is more than $184,000?
Absolutely.
Would you agree with me that $262,000 is more than $236,000?
Absolutely.
All of these years, despite you saying that you were a three-way partner with Wade and Campbell and Bradley, and now a two-way partner with Campbell, all of your corporate tax returns are filed in the law firm of Nathan Wade, though, correct?
My returns, yes, ma'am.
Yes, for your law firm.
Well, for my law firm, because I also have personal returns.
Right, and I'm not talking about your personal returns. I'm talking about your business returns.
Yeah, but the question contemplates that my bring home money is more or less. So I want to be clear that is reflected in my personal returns.
I didn't ask you anything about bring home money, though. I'm not sure what you're talking about.
What I'm talking about is your question was the portion of my testimony dealing with earning significantly less money.
No. My question is I'll just break it down. During 2019, you filed your business returns. I'm not talking about your personal. Your business returns for the law firm of Nathan Wade only, correct?
I filed personal and business. Yes, ma'am.
And even though you said you were partners with Bradley and Campbell later on, you filed your business returns not with them, but as a solo practitioner, correct?
I see where you're going. There's a different return for that Wade, Bradley, Campbell entity.
And I'm not asking about that. What I'm asking about is during the years 2019, 2020, 2021, and 2022, you filed a business return for the law firm of Nathan Wade.
Yes, ma'am.
And in 2019, you said that the law firm of Nathan Wade made $184,000, correct?
No, I don't know.
Does that sound familiar? Does that sound about like what you made in 2019 and recorded on your taxes as a business law firm?
If that's what's on the return, yes, ma'am, you're right.
Okay, and I'm happy I can bring those up. I've got one copy. I'm not planning on admitting them because they're tax returns, but okay. All right, may I approach, Judge?
Yeah.
Thank you. So in 2019, gross profit for the law firm of Nathan Wade is $184,000, correct?
Let's see.
The second line, number 2, gross profit.
Yes, ma'am. 184,824. Yes, ma'am.
Okay. And then in 2020, you also filed Nathan Wade, attorney at law, and your gross profit was $230,000, correct?
Yes, ma'am.
And in 2021, you also filed as a solo Nathan Wade, PC, attorney at law, and your gross profit was $236,000, correct?
Yes, ma'am.
And then in 2022, you filed as a solo practitioner Nathan Wade, and your gross income was $262,000, correct?
Yes, ma'am.
Okay. I'm not going to end the business. You've got your position. But nowhere in these documents do you document that you received cash payments from Ms. Willis, correct?
I don't. I hadn't looked through them. I would be surprised if there were something in there that said that.
Do you want to look through them?
Listen to the answer. I'd be shocked if there was something in there that said that I received some cash from Ms. Willis.
Okay. But there is itemized expenditures for travel in here. You did itemize that.
I didn't itemize anything.
Your accountant itemized it.
I hope so.
But you're responsible for your taxes, even if your accountant files them, right?
I agree.
And so you itemized your expenses for travel on all these documents, but you did not itemize, you didn't put anything in there about you being reimbursed for half of that travel.
Well, those are business returns.
Yes, you used your business
I
card
would-
to pay for the travel, right?
But I wouldn't put a personal expense on a business return.
But you
So
used a business card to pay for these
I use
personal travel.
I use a business card to pay for everything. And what I do is turn over the statement to the accountant, and the accountant then says, okay, this expense, that's personal. We'll put that over here. This expense, that's business. We'll put that over here. And they reconcile it. So you wouldn't find a reimbursement from Ms. Willis on a business return,
Okay, so they're not anywhere there.
nor would you find, well, go ahead.
No, I'm just asking. So there's nowhere for any of that cash to be reconciled there, right?
On the business returns, no, ma'am.
Okay. We talked a lot about the financial affidavits. I know the state asked you a couple questions about them. You filed one in 2022. In that one, you stated that you only had $5,000 in cash, correct?
I believe you. Yes, ma'am.
That was sworn under oath.
At the time of the filing, yes, ma'am.
Okay. And then in January of 2024, you filed another one that also swore that you only had $5,000 in cash, correct?
At the time of the filing, yes, ma'am.
Okay. So in 2022 and 2024, you only had $5,000 in cash.
At that time, yes, ma'am.
At that time,
And then you also, all of those interrogatories, I'm not going to go through them in painstaking detail, but every single interrogatory you filed, there are 4 of them, all verified ones. Every single one, you said you didn't have any cash stored in a safe, a safety deposit box, or any other location. Plaintiff rarely carries cash. If plaintiff does carry cash, it's a nominal amount, correct?
That's correct.
Okay. So we've got what? 2021, you said you don't have cash. 2023, you said you don't have cash. Again in 2023, you said you don't have cash. And then in 2024, you don't have cash, right?
So you're assuming that I received the cash and I stored it. I received the cash and I saved it.
Well, you didn't put it in the bank, right?
What's wrong with receiving the cash, Ms. Merchant, and spending it?
Nothing's wrong with it, but
So
you didn't
then
put it in the bank.
that would contemplate why the response is what it is on the interrogatories.
So you spent the cash. That's because before, when it was asked, you said you didn't want to disclose where the cash was.
No.
Privacy reasons.
No. Well, I said that if I were to store cash in my home, then why would I share that with the world, is what I said. I didn't say that I had some cash stored up in some place, because that's not the truth.
And you've talked a lot about this, I split with a third, I split with half, from the check you received from Fulton County, July 15th, 2022. So all the way back for July 2022, not a single check that you've received from Fulton County has gone into a joint banking account. Every single check has gone into your own personal banking account, correct?
All of them, with the exception of the checks that were going into the WBC firm, went into my business bank account, which is solely in my name.
Right, your WBC account that you're talking about, that account was closed, though, in June of 2022.
Correct.
So everything after June of 2022 was put in a Nathan Wade bank account, not a corporate bank account with
I'm going to ask
partners.
Willis to be permitted to.
I think the question right before that only needed a yes or no.
So no, ma'am. The checks were deposited into firm accounts, law firm accounts.
Law firm of Nathan Wade PC.
Yes, ma'am.
As a solo practitioner.
Yes, ma'am.
Okay, so they were not deposited into accounts with Campbell or Bradley.
No, ma'am, they were
Okay,
not.
thank you.
However, there were checks written to Campbell and Bradley that will reflect the third.
And we've tried to get those bank records, but you've objected to those, correct?
You've tried to get what bank records?
We subpoenaed bank records, and you've objected to all of those, right?
Your Honor, I'm going to object to the relevance.
It's relevant if he's saying he has all these records, but yet we've tried to get them, and he's trying to keep them from us, but he doesn't bring all of the records. And you can make an inference if there's law that says you can make an inference if some documents are within the party's control and they won't provide them, that there's an inference that they're not positive.
Ms. Cross.
Your Honor, there was no obligation for Mr. Wade to produce evidence that Ms. Merchant couldn't find an admissible way to produce. I believe it's irrelevant. We've covered the ground, and I object to any further questioning.
All right, I'll sustain that. Ms. Merchant, let's find some new ground here.
Okay, thank you. Are you willing to waive your privilege with Mr. Bradley so that he can testify?
I am not willing to waive attorney-client privilege.
Okay, thank you.
Only on the questions, the health questions that were asked. And I can ask it from here for the immigration. I don't want to get into the type of cancer. I don't want to get into the medical condition itself. Did I understand you to say that you had cancer in the year of 2020?
Yes, sir.
And you explained that because of that, in 2020, you were or kept yourself in a sterile environment?
I tried, yes, sir.
Now, what about 2021?
2021, just focusing on my health, trying to get back to myself.
You remember I asked you some questions about Hateville
Yes, sir.
and the condo?
Yes, sir.
And you indicated that prior to November 1st of 2021, you had spent time at the condo, the Hateville condo,
Yes, sir.
with Miss Willis, right?
Yes, sir.
And with someone else? You said Miss Yurty?
Ms. Yurdy, yes, sir.
Okay, so you were not concerned, that was not a sterile environment, was it?
Are you inferring that Ms. Yurdy and
No,
D.A.
I'm
Willis
saying
is not sterile? Of course it's a sterile environment. It's a condo.
But don't you remember then I followed up and said, where else might you have been to show your cell phone records from Hapeville? And you said, the airport, right? Not a sterile environment though, the airport, you agree?
It is not.
Okay, what about restaurants? Not a sterile environment, right?
They are not.
And the Porsche, you said something about a Porsche what?
Force experience.
That doesn't sound very sterile to me. Is that a sterile environment?
You're inside your vehicle.
Yeah, but don't you mingle with others?
You can.
Yeah, and you were doing all that in 2021 before November 1st. That's what you testified to, correct?
Yes, sir.
So there's no reason why you couldn't be dating in 2021, is there?
You mean 2020, Mr. Sato?
No, I said 2021.
All right.
Correct?
Dating? No.
No reason.
No reason.
Yeah, thanks.
All right, Mr. Gillen? Okay. Mr. Stockton, excuse me.
Just real briefly, you said you started dating in early 2022, and you also used the term personal relationship. And there was no dating, no personal relationship prior to early 22. Is that correct?
Help me understand. I want to make sure I answer you. So let's be clear. 2022 was the start of any intimate sexual relationship with a district attorney.
Okay, and that's what I was wanting to
Okay.
make clear. In your affidavit, you used the term personal relationship.
Got it.
Today, you've used the term dating. And your testimony today is that that includes the term basically physical or sexual or intimate relationship. Is that correct?
Yes, sir.
And there was nothing, according to your testimony, there was none of that prior to early 2022.
That is correct.
That's all I've got, Judge.
All right, not seeing anyone else. Ms. Cross, any redirect? All right, Ms. Merchant, can this witness be excused?
Judge, we asked to keep him under subpoena. We might need him to come back after the
All right, you may sit down, Mr. Wade, and please don't discuss your testimony with any other witnesses.
She mentioned subpoena, Judge. Let me just say this. That was an inference made that I was somehow evading service of a subpoena.
We can take that up. I don't think we need to have it on the record in this hearing. Understood, though.
Thank you.
All right, Ms. Merchant, any other witnesses?
Yes, we would call Fani Willis.
All right, Ms. Cross.
Your Honor, I am going to object and remove to the motion to quash district attorneys. There's been now lots of testimony from Mr. Wade. I don't believe that there can be a showing for the need for the district attorney to testify as well. For all of the reasons that were cited in the state's motion to quash initially, it's a tremendously high burden to call opposing counsel. I don't believe it's been met, particularly given the cumulative nature that would be the subject of personal details that Mr. Wade's not testified to.
All right, Ms. Merchant, what do you think you can establish and have through the testimony of Ms. Willis? And let me start there.
Conflict in the evidence, Judge. Now that how Mr. Wade has testified, there's a conflict in multiple different issues. I'll just go through all the different issues. The first one is the reimbursement issue, the cash. That opened the door in and of itself to Ms. Willis testifying.
Well, what's the conflict there?
That he testified that he didn't have receipts, but we don't know if Ms. Willis has receipts. So that's one issue.
So we don't know. So there's no conflict. We just don't know.
We don't
right?
know, right? We
Okay.
don't
So it's a
know.
question, not a conflict. But what else?
That is a question. So, and there's a lot of different issues with different reasons. The first one would be the receipts. Whether or not these cash payments, if there's any payment receipts. The Belize trip, whether or not she paid for the entire thing in cash. Mr. Wade doesn't have knowledge of that. He couldn't remember a lot of things he couldn't remember. So now it goes to Ms. Willis, unfortunately. That he testified that she insists on paying her own way. Gave him some cash. That's the quote, some cash. Miami trip. She booked it but thought it would balance out. A couple other trips that we didn't get any information about. Tennessee, Alabama, Georgia. All of those could be financial benefits. We don't know. He didn't know. He was very vague about that. Yuri, her best friend, testified that it happened in 2019. And now Mr. Wade has testified that the relationship began to become romantic in 2022, I think is what his testimony was. So that is a conflict in and of itself. Right there, that's a big conflict. We've also got more receipts. But the biggest thing about the conflict is when the relationship started. He said he talked with Willis in the conference room after we filed our motion. He specifically didn't use the term cash in the affidavit, but he told anybody who would ask about the cash. And he specifically discussed this and the response. We have a right to go over this.
All right. So you've highlighted the areas you'd like to go into. I think the central question may be, what is it other than, I'm just really curious what she has to say, you have to put on the record. So that's what I'd like to go through. Ms. Cross? Still with us on Zoom?
No questions, Your Honor.
Mr. McDougald.
I do have a couple, Your Honor, but it's a little awkward from back here. Do you want to?
Yeah, why don't you go ahead and make your way up?
Good afternoon, Ms. Willis. How you doing?
I'm very well. How are you, Mr. McDougall? I think this is our first in-person meeting, correct?
Second.
Second? Well, I apologize for not remembering you more clear.
That's quite all right. I'm referring now to exhibit number 21,
Yes, sir.
which was your financial disclosure form for 2022.
Yes, sir.
And it has a question which requires you to disclose any gifts or favors from a single prohibited source in the aggregate amount of $100 or more. Do you see that?
I don't, but I believe you.
It would be on page 2 in the middle, paragraph number 3.
Yes.
And what is your understanding of a prohibited source for purposes of this form?
I believe there's some classification of somebody you like don't have a personal relationship with that gives you $100.
All right, if you look
somebody
under there
Sorry.
at subparagraph 2, Romanet 2, it defines it as someone that you know or should know is seeking to do or is doing business with the county, correct?
Yes, but yes, yes.
That includes Mr. Wade as of the date you filled out this form, correct?
Yes, but he never gave me a gift of $100 or more. The only thing that I would say maybe went over that, but I don't think it ever did, is if we went to dinner and my meal was $100, but I don't think I've ever eaten $100 worth of food at a restaurant, because I would not pay him back if we went to lunch or went to dinner. But trips, I paid him back for. You know, I never thought about the money until y'all brought it up, and I would be less than honest that says I was giving him the money back because I was the district attorney. I didn't take gifts from him for a lot of personal reasons. Anyway, I did not take gifts from him.
And so your reason for not disclosing any gifts from Mr. Wade on exhibit number 21 is that the aggregate amount on a net basis was less than $100 in the year 2022. Is that correct?
I did not accept a gift of him of more than $100 in 2022. The one exception to that, because I want us to be clear, is we probably went out to eat multiple times in the year. If you're considering eating a meal, you know, because we went out multiple times, that probably went to the level of more than $100. But if we're doing tit for tat like that, I probably paid for as many meals as he paid for. And so I did not receive any gifts from him.
The question on the form,
I understand the
the
question.
aggregate in excess of $100, and your testimony is that you did not receive in the aggregate more than $100.
All right, Mr. McDougald, you can sit down now.
I don't believe she answered that question, Your Honor. She answered as to specific individual gifts.
And you're not listening to my answer either, so we're done.
Very well.
Okay, Mr. Rice.
No further questions.
Mr. Gillen.
Good afternoon.
Good afternoon, sir.
A few questions here. I want to. You saw the book here, "Find Me the Votes." That was shown to you, correct?
Yes, sir.
Your Honor, I would like to just tender this as an exhibit, number 22.
Is that your copy?
It is.
All right, what exhibit is that going to be?
22.
All right.
I'm making the
Is that
evidentiary contribution here to this. Now,
well? I guess you're tendering it. Is it with position of the state?
I'm going to object this to the relevance at this point. There's no relevance at this point.
Mr. Gillen, are you using this to confront her with prior statements?
yes, Your Honor, and
Okay.
statements that she made concerning her concerning her financial situation and laying the foundation for that, and that she gave these interviews to the authors. And so this would document that, and we ask her, get this in the record, ask her questions about it.
Well, we could mark it for impeachment purposes. I'm a little wary of entering an entire 300-page book because I don't know exactly what every single line, if it would pass hearsay or relevance or et cetera, et cetera. But I don't think it needs to be admitted as an actual evidence for the record for you to do what you need to do with it. So,
Well, Your Honor, I understand. I just would.
it's marked as
again,
Exhibit 22, and we'll move from there.
Thank you, Your Honor. Now, you were asked a little bit about this book before, correct?
I think Mrs. Merchant.
Ms. Merchant did.
Asked me some questions, yes.
And you gave about 6 interviews to the authors of this book in the sit down?
No, sir.
You didn't?
No.
Was it?
She answered how many interviews she gave, in her opinion.
How many, in your opinion, do you believe you gave, and how long did they last?
2 to 3, maybe 20, 30 minutes.
So your testimony is at most, you think that you gave maybe an hour to an hour and a half's interview to the authors of this book?
Oh, you mean in total?
In total, yeah.
Maybe, yeah. Anywhere between, definitely not more than 2-ish hours.
Okay. But you also were telling, when they were, the title of the book, of course, is A Hard-Charging Georgia Prosecutor, a Rogue President, and the Plot to Steal American Election. You've seen
had-
that.
Why is the title of the book relevant, sir?
And I had no,
And then I'm going to ask her whether or not that was the theme that they gave her when they talked with her.
What the thing gave her? What do you mean by that?
Well, because they were sat down and they told her why they were there to interview her.
And why does that matter?
Well, I think it matters because it shows what they want her to give her version of what her life story is. This is almost a life story of her. So that's why it's relevant. But if the court thinks it's not, then
No. It could be relevant to your issue of the forensic misconduct that has been alleged, and maybe some of the motives at play when it comes to forensic misconduct. But I'm not seeing, again, what we're here for today was the relationship and/or any financial elements of it.
correct. Well, I think it clearly relevant to the forensic misconduct, also relevant to the personal interest in terms of the finances.
I didn't make 10 cents off that book.
Pardon me?
I didn't make 10 cents off that book.
Didn't ask whether you made any money.
Okay, I just,
Didn't ask whether you made any money.
Do you have any other statements that she hadn't already been confronted with by Ms. Merchant?
Well, other than I want to focus on when you were telling them about your financial straits and you're living kind of month to month, that is what your financial status was back in 2018 after your election.
Mr.
correct?
Gillen, we covered that at length, and you're at the end of the line. I'm sorry about that, but we've got to find new ground.
Well, let me move on to my point here. So the point is that what you're telling us is that you were in financial straits, but really that your testimony today is you had a cash hoard of maybe up to $10,000 in cash where you laid your head at night so that you would dip out and there would be no record of it, correct?
that's not what I'm telling you, sir. That's not at all what I'm telling you. What I'm telling you is that throughout the course of my life, I have always kept cash in my house. That cash has ranged from times, my father would probably be ashamed of this because he would say it should be more. But that cash at times has ranged from $500 to maybe $9,000, and he would be like, that is not what I told you to do. I've always had that amount of money. What I've told you is that when I travel, you do better negotiating when you travel. If you have cash, you go to get the cab. They say, "Oh, we're gonna charge you $300 for the day." Well, I got American cash. Will you take it for $150? And so it's my practice to take money when I travel. We're not talking about a whole lot of money. We're going to the Bahamas. $1,500 in cash is in my pocket, or at the most $2,500. Belize was actually probably the most money I've ever taken. And it was taken because it was a big deal. My 50th birthday sucked. His 50th birthday, it sucked. It was terrible. No.
Your Honor,
And
I'd
so
like to get back to some questions here.
I'm trying to answer
rather
it.
than
I think it
narrative.
would help if we
So let's
get a question
let's
here.
move to the specific yes or no's here. Have you told us today that you would keep a cash hoard in your residence up to about $9,000? Yes or no?
And throughout the course of my adult life. And so let's even be more specific than that. Probably from the time,
Your Honor, I'm only asking for yes or no rather than
But I-
But
speech.
we have already covered this, so I
But
need
yeah,
to
but
get
I'm
to that
trying to
point.
move- I'm
I know you're
trying to
laying the
move forward
foundation, but
other
it's already
than-
been laid. So
Yes.
The filibuster is here. I'm trying to move through the filibuster.
yeah, but we're not talking about a lot of, and so it could be 2,000, it could be 1,500, it could be 7,500. It just depends on what you're doing at that time. What I'm telling you is when I traveled, I took cash. I find that when you travel, especially to foreign countries, the American dollar does well, and it's good to have cash. You can negotiate with the taxi driver, with the jet skis, and it's not a lot of money we're talking about.
Your Honor,
Okay,
we
understood,
need
Ms.
to,
Willis.
we need
Let's
to
get
cut
to it.
off the.
Let's get to a
narrative
question, Mr. Gillen.
And so you have cash in your house, but you had a lien, a tax lien on your property. Is that right?
I don't believe I had a tax lien on my property.
You didn't have a tax lien on your property.
You gotta talk up louder, Mr. Hunt.
Cumulative, Your
Okay,
Honor.
we already covered that, Mr. Gillen. I need new ground here.
I'm asking the question of, I'm trying to figure out how someone can have a tax
Then
lien,
ask that question.
but not use the money that they allegedly said they have.
Well, I think Ms. Merchant asked that exact same question. She said she didn't use the money to pay her tax lien. So what's your question that's new?
So I was going to build on that to say,
No more building. It's already built.
all right,
It's the same way you pay a bill.
So just put
It's
the
a-
top on it if you need to,
It's the
okay?
same way you owe a bill and go shopping.
well, now, have you ever used, did you say earlier that you used Cash App?
When I would pay Robin Bryant, I used Cash App.
What is Cash App for the record?
I don't need to know that for the record. Let's keep going.
Well, so if you're paying Robin with Cash App, why aren't you paying, allegedly paying Mr.?
There's no alleged here.
Why aren't you paying allegedly Mr. Wade with Cash App?
I don't think Mr. Wade does Cash App.
Did you ask him?
I think he's told me he doesn't do Cash App.
Okay, so that's the reason why you didn't use Cash App,
He's sitting next to me. I hand him the money.
because there would be a record in Cash App of your making payments, correct?
Yes,
Right.
but I didn't think that I was making a record in a personal relationship.
Because when you're filing your, and I know that I'm going to move into this financial statement here, you were asked just a second ago about your non-disclosure form, or your disclosure form of an Exhibit 21, where we agree that Mr. Wade is a prohibited source, correct?
What I agree to is I don't believe he's giving me gifts. You would like to classify these trips as gifts, but I've always paid my fair share on these trips, so I did not look at them as gifts. I don't think that what this is disclosing, and they can tell me if they mean something different, I don't think it means that if you go to dinner with somebody over the course of a year and it gets to 100, you're supposed to report it. If my understanding of that is wrong, I've probably been to lunches with a couple of people that over the course of a year I paid.
Let me, prohibited source means,
We already went over this, Mr. Gillen. Mr. McDougall.
well, Your Honor, I have to lay the foundation here before I can follow up with my next question.
I don't know why you can't. You have to.
Well,
It's already, the
okay,
questions have been made.
Then your 2022 disclosure form did not list any of the thousands and thousands of dollars that Mr. Wade paid for on trips that you were on.
Objection.
Isn't that correct?
That's because Mr. Wade was paid that money back, or he was paid due to the fact that I bought the plane ticket or I paid for the hotel. There were never money that he gave me. That wasn't the nature of our relationship. You know, there's so many men, and Mr. Wade is one of them, where the nature of the relationship is they're just paying a woman. The nature of our relationship is companionship and friendship. Despite the way people would like to paint certain women, it's just not true.
Final question. And not a single solitary documentary piece of evidence showing that you have withdrawn the cash to pay him
All right.
back.
Thank you, Mr. Gillen.
That's not accurate.
Thank you.
Okay, Mr. McCullough, on behalf of Mr. Floyd. All right, and Mr. Cromwell on behalf of Ms. Latham.
Great thing about becoming last is most of your questions. I had one question, Ms. Willis. Can you hear me?
Yes, sir.
In the time period between February of 2021 and January of 2022, while you were staying at the Yurdi condo, did your father ever come and visit you during that time period at the Yurdi condo?
He did not.
That's all I have. Thank you, Your Honor.
All right. Ms. Cross, I would imagine you have a number of topics to cover with Ms. Willis that'll take more than 10 to 15 minutes.
I do.
Okay. Then I think we've reached a stopping point for today. And so, Ms. Willis, I'd ask if you could step down now. And I'd also remind you that you're not to discuss your testimony or that of any other witness until tomorrow morning. We'll be back here, and we'll begin again at 9 a.m.
9 a.m.
We'll do 9 a.m. this time tomorrow. Before we recess for today, I want to check in on logistics, and I'll ask Ms. Merchant. Once the testimony of Ms. Willis is concluded, how many other witnesses do you anticipate calling?
And then we subpoena Delta records that the state objected.
We can handle that now. Ms. Willis, you can step down. You're done for the day.
You want me to leave the courtroom?
Or you can sit at the council table. We don't need you in the witness box. All right, so 2 witnesses, and then querying other defense counsel. I know Mr. Gillen, there was a potential witness that was objected to by the state, so there's another one there. And we can talk about that. Were there any other witnesses anticipated from any defense counsel? All right, seeing no show of hands. And then Ms. Cross, any witnesses on your behalf?
I expect so, Your Honor, and I expect that to take 4 to 5 hours.
Okay, and how many witnesses would you imagine?
Without committing myself to a final number, my best guess at this point would be 3 to 4.
Okay. All right.
We know who, I mean, I gave them our witnesses. I know we're supposed to give witnesses from evidentiary hearing. I'm guessing that one is John Floyd, but I don't know anything else.
All right. No, I understand, Ms. Merchant. However, I don't think at this point there's any statutory requirement. We have the standing order that for expert witnesses, and if state doesn't want to extend that courtesy, then I think you're stuck with it. All right.
I'm certainly happy to represent that Mr. Floyd will be a witness, that the other witnesses will be impeaching of Ms. Yearty.
Okay. All right. Let's take up these last couple issues here before we break. Then the issue of the Delta Airlines records. The motion to quash was filed by the state on behalf of Ms. Willis, I believe.
I didn't file a motion, Your Honor.
Oh, excuse me.
But my representation was that I just got notice of them, I think it was yesterday.
Okay.
And so now that I've had the review of them, I object to the general fishing expeditions. I've introduced a new record today that was from Delta. To my knowledge, there's going to be no further new production in the Delta records. I don't want to burden the court with anything. If the court wants to take a look at it and see if there's anything different than that, I don't have an objection. I don't like the idea that we're just looking for anything. I don't want to put an obligation on the court, but I'm happy to agree to it in camera if that's something the court's interested in.
And so, Ms. Merchant, I take it.
Tomorrow to 5 points.
All right. So, Ms. Merchant, I take it the purpose of this subpoena.
Martin Luther King Jr. Drive Southwest.
I'm gonna need you to step out.
Onto Peachtree Street.
Step out, ma'am.
Judge, the purpose is to show travel records.
Right. Is it because you suspect there are other travel records, or just you think there might be something else in there?
It's, well, one is to prove some of the travel records that they traveled together. And so we have no problem, like I told the state, putting them in camera. I don't even think.
I mean, what I'm saying is if we've heard about the trips today in detail. Is there anything else that's in these records that you're saying is going to prove some additional trip, or is it just further corroborating what really is kind of uncontested at this point?
There may be some additional trips.
But you don't know of any specifically. You just think there might be any. Okay. All right. Well, then let's continue with that. Then, if you want to send them or instruct Delta to send them to us in chambers, we'll take a look. And I think essentially, if there's, you can tell us, Ms. Merchant, what you think we should be looking for and what you think is relevant, and we'll do that.
Thank you.
Okay. All right. And then when it comes to Mr. Schaefer's witness, there was an issue raised about this kind of being a summary versus an expert witness. And so I reviewed the motions, and I think there was the essentially kind of the summary document that Mr. Gillen's witness would, the sole purpose of this witness to introduce. Was there something about, I don't know whether it's from Mr. Abadi or Ms. Cross, was there something about this attachment substantively that you think is inaccurate, or is it literally just a summary document?
I can't tell because the documents to support it were on a thumb drive, and there's tens of thousands of those documents, and so I don't know whether that is accurate or not. I can point to some characterizations on it that I would quibble with.
Sure.
I think the result is wrong, but I just can't agree to include the documents or someone testifying from the documents that I just can't verify. It may well be that there isn't anything ultimately, but I can't represent that and I can't agree. The document itself isn't authored or identified as being authored by any particular person.
Okay, give me a second while I pull it back up.
Thank you.
So what I was provided by Mr. Gillen is a 3-page document. It starts with a timeline, usually dates, events, and sources, and it ends with an Excel sheet with some more figures. And Mr. Gillen, what do you have to say on this?
What we would tend to call Bill Selensky as a summary witness, not expert, not giving expert testimony. And what we've done is that we have, we got the bulk of sort of what was in the download we got last week as a chamber team. So what we have here is the source information over here. If we look at that, Your Honor, that's largely, all of this information essentially is material that is material of Mr. Wade's. This isn't something that's some different company or bank account. And largely what it is a situation where, as it now stands, most of these source documents are already in evidence. And so, whether it's 1006 or frankly a demonstrative aid under 611.
Well, that's what I was about to say. Why couldn't this just be used as a demonstrative? What would the state's objection be then if Mr. Gillen was just to say in closing, hey, I put all these records together and here's my demonstrative?
I don't think I have an objection to that. I might quibble with some characterization in some language.
Sure.
But to call it a summary and to represent that the records is an accurate reflection of the records, I just can't agree to because there's so many records that were disclosed on Wednesday, and I just don't know.
Well, except, Your Honor, if you look at the sources, I mean, literally, we're describing things that were introduced today. They've seen all this. And the documents that we have sourced really came from Mr. Wade in his divorce case. So it's not like they're surprised. So we would ask that the witness be allowed to testify and just put it in the record and put the summary charts in the record and have them admitted, and that way off we go. This isn't a situation where we have a jury and they're overwhelmed with whether or not there is some kind of factual misunderstanding here. They could look through this probably at lunch and determine whether the source is accurate or not. The second sheet, Fulton County payments, that came from them. So to say that they can't determine or decipher whether the documents they gave to us is accurate doesn't seem to carry the water. This isn't a situation where we have tens of thousands of new and different documents from different corporations, different banks, and then suddenly we've put it on. We've done our best. We got these things last week. I've gone through them all, and we've called it down to what we think is a very concise summary chart for the board's consideration.
All right. So, Ms. Cross, what I would ask is, it sounds like most of the morning is likely going to be taken up with the remainder of Ms. Willis's testimony as well as any additional witnesses from Ms. Merchant. And so perhaps we can use that time between then and then the lunch break to take a look and see if these sources are inaccurately cited. I mean, the characterization isn't something that's going to be determinative. I don't think I'm bound by whatever he describes as the event. But if this is just, I really don't see much of a substantive distinction between a demonstrative and a witness. But if he wants to put it up through a witness, and it's not something that you need to rebut with expert testimony of some kind, then I really don't see this as being much ado about nothing.
Your Honor, I'm sure you can
Yeah.
understand why I couldn't agree.
Sure, no, that's fine.
Without having gone through the
But I don't know if it's something that we need to bar outright until you've had a chance to look at it, if you see some incredible inaccuracy in it or something like that. All right, anything else from the state?
No, Your Honor.
Anything else from defense counsel? Let me go in order. Mr. Sadow.
One quick question. I understand the court had the bullet point where I was going to go. Do we need to put into the record the speech itself in the transcript, or is the court taking notice from what we've already filed?
I think it's extensively quoted in all of the pleadings. If you feel that's something that we need to have officially recognized, I think certainly we can do that. I don't know if the state has a particular version or a pleading that they want to double check for accuracy, or it can just be something that's as assumed as a matter of law as pleaded by defense counsel, and then we could make a ruling on it from there. But
There's certainly no certified transcript that I'm aware of. If they want to give me the version that they believe to be accurate, then I'll certainly take a look at it.
okay.
I have a USB that my paralegal downloaded onto a USB drive. You can take it home.
All right, and that's also not something I think we need to have done by tomorrow. I'm not going to be ruling on. Yeah, I mean, I'm not ruling on any of this tomorrow. I mean, this is something that's going to be taken under advisement on all aspects. So the forensic issue we can bring up, and we may need to bring everyone back if everyone needs an extensive, not even extensive, but if everyone just wants to be heard in argument in some way, we're probably not going to have time for that tomorrow either. So my hope is perhaps we can just close the evidence tomorrow, and we'll take it from there.
I think we're going to want to have an argument, and I've already requested, depending on how busy the court reporter is between now.
Yeah, the answer is they're all busy, and we don't have enough of them. So
I don't know. This court reporter was giving me a potential of a reasonable time period. But is that what you just turned over to Ms. Croft? Does that also have a transcript?
No.
Or is it just having a video?
It's got the USB video. I believe that's all it is.
again, I think that's something I'll just wait for direction from the parties on. I don't think that's something we've got enough to deal with tomorrow, and I think we can handle that as it comes once we've had a chance to take a look. Okay?
So no arguments on the motion?
I doubt we're going to reach it if the state has 4 to 5 hours of witnesses and.
That's not just a question of preparation.
Yeah, I don't think that's going to be needed. Okay, Mr. McDougall.
Just a very short housekeeping matter. You ruled on Monday you didn't want to hear any evidence about the county ordinances and so
Sure.
forth. The statute 24-2-221 requires that they be put into evidence as opposed to being cited as law. So before the defense evidence closes, I would like to tender certified copies of those. I don't need a witness
Sure.
for that. And then I've got one other certified copy that I want to tender. I don't need a witness for that. So that would just be a little mechanical thing right before the defense evidence closes, Your Honor.
Understood. Any thoughts from the state on that? Okay.
As the representation, if that's what the exhibits are, then I'd consider it a proffer more than evidentiary, but that's fine.
Okay.
I didn't want to upset the court's expectations tomorrow when I did.
Okay. Well, Mr. McDougall, my expectation tomorrow will be that when I talk, I get to take prominence, right?
You're the boss.
Thank you, sir. Okay. Anything else?
I'm going to state, Your Honor.
All right. We'll be in recess 9 o'clock tomorrow. Thank you all. Sorry?
Copy that would give you tomorrow.
You're going to give me ideas.